Hi everyone. So coming to our next video in continuation for the part 1. So in this part 2 we'll be covering question 1C and question 1D. So quickly going into the question, as you can see this question, A, who is indebted to B, appoints B as his agent to sell the land of A. So by this first sentence you can understand the question is related to concept of agency, which is chapter 10 of Contracts Act. So and this statement states that a person has to pay some amount to B. So A is indebted to B and A also appoints B as his agent. So here B is acting as an agent and A is the principal. So why did A appoint B as an agent? So the reason is to sell the land of A and to pay himself out of the proceeds of sale the debt due to B. So what A has thought is to appoint B as an agent to sell A's land, and whatever the amount has been coming out of it by selling the land, the debt he wanted to cover the debt of B with that amount. So A is also informed that B, after plotting the land, has sold away some plots without accounting for said sale proceeds. So B here did not tell the information regarding the sale proceeds to A. Can A terminate the agency of B? Are there any restrictions on the power of A to terminate the agency given to B? So here this question they are asking, can the principal terminate B and can he terminate the agency, and are there any restrictions on behalf of the principal? So firstly, to understand in detail, if we go, so section 182 speaks about agent. So 182 of Contracts Act speaks about agent. So basically, who is an agent? Agent is a person who is employed to act or to represent on behalf of other person. So this other person is none other than the principal. So this person is none other than the principal. And this concept is known as agency. So a person is employed on behalf of other person or to represent the other person in various acts and dealings. So when all this is done on behalf of principal, the person doing this is called as agent, and all this scenario is called as agency. So a agent should be he can be any person, but he or she should be the major or with a sound mind. So these are the basic conditions or the ingredients that a agent should be having, because he will be responsible for all the acts which he is doing on behalf of principal. So he is appointed for all the acts to do on behalf of principal. So this is the basic explanation of agent, section 182. So while talking about termination, under section 201, there are certain essentials or important keys on which a agency can be terminated. So basing on this, the termination, there are certain essentials where the agency can be terminated. So the things we will be discussing right now is, one, the principal have the revoking authority. So if principal revokes his authority, then the agency can be terminated. The second cause can be the agent renouncing his business. So the agent itself renouncing his business as an agent. The third condition can be a business of agency when it is completed. So if the agency is completed, then it can be terminated. So the next one, where the principal or agent is dying or becoming of unsound mind. So where principal or agent dying or becoming of unsound mind. So these are the conditions for which a agency can be terminated as under section 201. So if you go through section 202, this is our answer. So section 202 is important and it is related to this question. So section 202 speaks about termination of agency where the agent has interest, where the agent has interest in the subject matter, in the subject matter. So this section explains that suppose in case of the above explained matter or the above question, whatever it is stating, the agency cannot in the absence of an express contract be terminated. So that means the agency cannot be terminated. So the answer to the above question is the agency cannot be terminated unless there is an express contract. So here basically just at a glance, two types of contracts, right? One is express contract and the other kind is impress contract. So express contract is basically it has to be either orally or in written form. Whereas impress contract, express and impress contract or implied contract. So this is a contract where the contract is formed by the action of parties and there is no such verbal or written explanation or any agreement. It's just formed as if according to the obligation or duty or the action of the parties. So this is called as implied or impress contract and the opposite one is express contract. So here under this section what it is stating is where in the case of this above matter as in the question which I have explained earlier, the agency cannot be terminated unless there is an express contract. That means unless there is a written contract with terms and conditions or some orally a contract has been made between agent and principal regarding few terminology and conditions like if you do so and so thing you can be terminated or any other in detail explanation. So if there is no express contract, the agency cannot be terminated simply by stating that this as under any of the cause. So just refer to not to section for this. So here we can also go with one more explanation which is given in the illustration. So if you can see in the Bare Act under 202 section, you will have the entire definition and entire explanation of this concept. And here they are asking, are there any restrictions on the power of A to terminate the agency given to B? So for this, you can refer the illustration which states that A gives authority to B to sell A's land. So B has now an authority to sell A's land. So here B is an agent and A will become principal. So this is done to pay himself out of the proceeds or out of the debts which A has been owed to B, right? So here A cannot revoke this authority. A cannot revoke this authority nor it can be terminated. So A either cannot revoke this authority nor it cannot be terminated by his insanity or death. So before if you can see under termination of agency, we have seen it can be terminated by either principal or agent dying or becoming an unsound mind. But in this scenario, the principal cannot revoke his authority, or neither he can terminate the agency either by insanity or even death, because this will be as an exception to this the question asked. So this is what you need to write for this question. So the answer is, can A terminate the agency of B? No. And are there any restrictions on the power? So you can refer to this section and illustration. So now going to the next question. Can limitation be set up as a defense at any stage? Yes. So just in simple, first let you know the answers, yes. Or whether the defense of limitation has been pleaded, specifically explained. Yes, obviously. So now we will go into the explanation part of question number 1D. So as you all know, the concept of limitation period. So why does a concept of limitation period exist? So basically the limitation period is to set some time limit, right? So it is to set some time limit for some legal actions or claims or any other suits, so which are to be brought up. So all these particular things have certain time limit. So once the limitation period expires, suppose if the limitation period expires, then what will happen is the time will become dead. So after the limitation period, you cannot proceed with the next claim, right? So once a claim that would have otherwise been valid or becomes time barred. So before the limitation period, a claim which is valid, after the limitation period, it becomes a time barred. So what is the defense, how the limitation works? Now we will know. So at any stage, the one thing which you have to know is, can limitation be set up as a defense at any stage? Yes. The defendant can take or can show the limitation period as a defense. So the defendant have the right, and he can typically show that a limitation period as a defense at any stage of the suit. So whether the defense of limitation has to plead specifically? Yes, the defendant have to plead that the limitation period of the said suit or the claim has been expired before the court. So he has to plead this regarding the limitation period specifically. Because the defendant needs to raise this as an affirmative defense in their response or pleading to respond to the plaintiff's allegations. So failing to do so, what will happen? If the defendant will not raise this as a defense at any stage, what will happen is he will be treated as defense waived. So if he is not asking the limitation period as a defense, or if he is not showing the limitation period as a defense, so failing to do so will be treated as defense waived on behalf of the defendant, and court will not consider the limitation period unless the defendant raise it as a defense. So it is a duty of defendant to raise this scenario as a defense to the case. So once this has been raised, what will happen? The burden of proof will shift to the plaintiff, and the plaintiff need to demonstrate that their claim falls within the limitation period. Otherwise, this will be in favor of defendant. So the burden of proof is on plaintiff to determine the claim stated by or the defense taken by the defendant regarding the limitation period falls within the timeline. So in some cases, there is an exception actually given by the court. So where the limitation period even after the expiry is still considered. So what is the exception is, suppose if any case is been falling under the scenario of fraud or misleading or having some disability persons having or undergoing some disability, or where there are some hidden injury caused to someone has been discovered. So in all these scenarios, the court has authority or to give extension to the limitation period. So as per the question, the defense of the limitation period can be raised in various stages. So at any stage, yes, it can be raised at various stages. So overall, the scenario of this question is, if it is not raised by the defendant, unless he is willing to state it before the court, or unless he puts his defense, it will not be considered and it will be treated as the defense has been waived because the defendant has not kept his claim in front of the court. And if he does so, the burden of proof will lie on the plaintiff to determine or to demonstrate regarding the defense raised by the defendant. And there are exceptions for this where a limitation period can also be considered after even the time has been met. So these two are some typical important questions where a lot of aspirants have queries. So just go through this video. So I hope you can understand this in a clear way. So see you in the next video with the upcoming questions.